SJC-13728, Commonwealth versus Adonis Carvajal.
Okay, Attorney Nocum.
Good morning, Your Honors. May it please the Court. Attorney Jalanpan Nakan on behalf of the appellant juvenile. I briefed two issues and hope to get to both. I will begin with the DNA. The Commonwealth here conceded that the police unlawfully took the juvenile's DNA at booking, later calling it egregious. Post-indictment and a few years later, then filed a motion to compel. The motion to compel was granted by the motion judge after hearing from officers who were not present and who were not the ones who took the buccal swab at booking. In her decision, the motion judge ruled that the Commonwealth met its burden under Maxwell and further analyzed that the police officers acted properly under inevitableness exclusionary waiver. That analysis was not based on any evidence that was before her. The judge ruled that the officers were merely ignorant of the law and that they did not act in bad faith. There was no evidence before her for her to draw that conclusion. In order for the court to conduct an analysis and come to that conclusion, she would have needed to, at minimum, hear from the officers who were at the booking and who conducted the buccal swab.
Is that why independent source is a better exception?
I'm sorry, Your Honor, I missed that.
Is that why independent source is more applicable? It doesn't have to do with bad faith?
Well, as an initial matter, where the Commonwealth conceded that suppression was appropriate, the analysis, we can assume that the Commonwealth considered all of these factors and found that it was insufficient. And that's why the concession to the initial suppression occurred.
Right.
But notwithstanding, under any of these analyses, if this court were to remand and require that the trial court conduct a further inquiry, then whatever inquiry that is would require an additional step of assessing the police's character, the character of the police conduct.
Can I ask you why? Because the Commonwealth isn't trying to reintroduce the results of the suppressed DNA analysis that was done that is properly excluded, and the Commonwealth concedes that. What the Commonwealth is doing is taking the information that they have, not relying on the results of the unconstitutional buccal swab 1, but just on the information that they have other than that, to ask for court permission for a second buccal swab.
I would concede that the Commonwealth would have been able to, and they did, meet the Maxwell standard for probable cause. I think the issue is whether or not the court appropriately considered and had sufficient evidence to come to a conclusion that the officers did not act in bad faith and that they were merely ignorant of the law.
But bad faith, as I see it, there are three exceptions that could apply. One is independent source, the second is attenuation, and the third is inevitable discovery. You're arguing bad faith. That goes to attenuation and inevitable discovery. It doesn't go to independent source, correct?
That's correct, Your Honor. What I'm asking for, if the case were to be remanded, is that the motion judge does consider the initial police misconduct in coming to the conclusion.
Under Vei Ming Zhou, we can affirm on any basis as before, so we have the authority to say there's independent source here, correct?
Absolutely, Your Honor. But I think that we cannot overlook the constitutional violation of this juvenile who was in police custody.
Well, that goes with Justice Wendland's position. You got your remedy for the constitutional violation. That was suppression of the illegally obtained results. You're not suggesting that the defendant is completely hidden from discovery once there was a constitutional violation. The cases say otherwise.
As to Your Honor's first point, I don't think the juvenile got the benefit of the suppression at all, considering the fact that the police officer violated his constitutional rights because that evidence actually was ultimately admitted, despite the fact that it was suppressed.
But it wasn't that evidence, right? It's just, it turns out that the results are the same, but the results of the initial unconstitutional buccal swab have been suppressed.
I'm sorry, Your Honor, can you repeat that question, please?
You're saying the same evidence is coming in, but it's not. The first buccal swab results are gone. They're suppressed.
The character of the evidence that's going to come in is going to be the same result. So they
That's,
take the
that
first.
may be true. That may be true, but tell me what constitutional principle precludes the Commonwealth from doing that?
Constitutional principles of deterrence, constitutional principles
But the
underlying the Fourth
deterrence
Amendment.
effect of the exclusionary rule has been meted out by suppression of the first buccal swab. So the deterrence is out. What's your next rationale?
The judge ruled on the Commonwealth's motion to compel that the officers were only merely ignorant of the law. We're going back to the inevitableness. What I think is critical here is we cannot overlook the fact of the first police misconduct or the unlawful conduct that resulted in that DNA. So the fact of the second motion and the order to compel his DNA, we're talking about the same basic evidence that ties the juvenile to the crime. So the Commonwealth, in order to get a second bite at this apple to fix its error, which is what the motion judge decided and ruled, is that they meet this standard under Maxwell and this other thing, which is an analysis into the character of the police conduct at the time of the initial unlawful taking of that buccal swab. And in doing so, the motion judge found that they did not act in bad faith, even though there was no evidence before her to make such an analysis.
So are you asking us to create a new rule? Because where is that infused into the independent source analysis?
I think a process that addresses that gap between police officers who unlawfully violate a suspect or a juvenile's constitutional right, and a process in which the government is then allowed to circumvent that in order to get that same bit of evidence. What we have here then is unresolved. The Commonwealth could always go back to file this motion to compel a buccal swab in instances where the police unlawfully took
Only if they have an independent source, however, correct?
Not necessarily, because Maxwell does not require this additional analysis into the character of the police misconduct. So we have then a suppression here, the Commonwealth conceded, violation of a child's Fourth Amendment rights at booking. So that is out. But now the Commonwealth still has this other avenue to pursue to get that same bit of evidence. And they are permitted to do so without analyzing or look into the character of the police misconduct initially, because they would just need to establish probable cause.
This is an aggravated rape, right?
It is an aggravated rape, Your Honor.
Right, so the decision to seek the evidence by lawful means is based upon the nature of the crime, not what they did before, what they discovered, correct? They got to test an aggravated rape, just DNA.
Well, Your Honor, I think that, as I said, the Maxwell standard here is met. The government was able to establish probable cause. And what we have here then is, what do we do with the initial unlawful taking of that buccal swab? Does it become a component?
You suppress results of that illegal buccal swab, or buccal swab, however we're pronouncing it nowadays.
I apologize if
No,
I'm mispronouncing.
I pronounce it both ways. So,
I've been saying buccal all these years and was
no,
recently
I'm 50,
corrected.
I'm either right or wrong, but
News to
anyway.
me.
Yeah, sometimes.
It's not buccal.
Buccal, buckle.
I'm told it's buccal, but I could be wrong as well. In any event, we cannot overlook the fact of the unlawful misconduct.
But what you're, I'm sorry. So going back to, I guess, I don't know if you ever answered Justice Gaziano's question, but you're saying for all time, if there is a constitutional violation that results in suppression, that by in and of itself is going to be state action that they shouldn't have done that was unconstitutional. So you're always going to insulate the defendant from a further potential swab, because irrespective of Maxwell and whether they can establish probable cause, you're always going to go back and say, but oh wait, initially you violated the defendant's rights or the juvenile's rights, so you're forever foreclosed. What scenario would allow for a further finding on your part? Because if there's a constitutional violation, any analysis by the judge is going to have to find that there was unlawful police action. So where are you ever going to get out from the bad faith component?
Well, I think that the court could conduct a hearing to consider the character of the police misconduct at the time of the initial unlawful taking of the DNA.
So this is new. This would be a new rule.
I think it is critical in order to address this gap
But
between.
so, yes, so this is, you're saying, I guess my question is, are there any cases that you can point to where we have said that before?
I have not been able to find, candidly, any cases that specifically address or come close to addressing this issue and closing this gap between an unlawful taking of a buccal swab and then another process by which the government could technically circumvent in order to still get that same evidence.
In some respects, though, the judge's finding of inevitable discovery supports your claim, because inevitable discovery requires police misconduct or an inquiry into police misconduct.
Yes,
As
except,
does attenuation. The judge here found inevitable discovery, right?
that's correct, except for the fact that there is no evidence before her to come to that analysis because
Right,
the
that's what,
officers.
right, exactly, which gets you to, I think the biggest hurdle for you is the third possibility, that being an independent source.
I think whatever exclusionary rule waiver that the court has to consider has to include an inquiry into the character of the police
Okay,
conduct
so
at the
this,
time
okay.
of the untaking.
So this would be the new rule. You want to put police misconduct into the independent source doctrine.
I don't know how we get around allowing the trial court to conduct this analysis other than to have evidence before the motion judge to consider all these factors. Because without that, then we have, again, the unlawful taking and an ability for the Commonwealth to then return to the court utilizing another process, basically circumventing the fact that there was an unconstitutional violation. And to not do that is to say, well, let's pretend that that didn't happen at all. So here, at least the motion judge ruled in part that that was a critical analysis to her ruling, except that it was not based on any real analyses. Really,
Okay, but you've never directly answered the question. I'm going to do a fourth time. You're asking us to create a new rule. That's a yes or no? Under the independent source rule, that you want us to infuse the same kind of analysis that we would under attenuation and under inevitable discovery. That's what you're asking us.
Yes,
Okay.
in a sense, I'm asking that this court, if this court were to remand, that the motion judge conduct an inquiry that is more robust than what happened here.
Okay, well, let me just follow up on that. So we've never said that before. Do you know of any jurisdictions that under their cognate or analogous independent source rule has ever done anything like you're asking the court to now do?
Truthfully, Your Honor, I'm not aware, and I don't want to state with definitively that I've done an exhaustive research into this issue, but I am not aware. But I think, I think that the motion judge here certainly thought of it as a significant enough issue to at least put it in her decision. So I think that in order for the Commonwealth here to get essentially a second bite at the apple, which is what they're asking for.
Let me ask you a hypothetical question, if I may. Assume police interview a defendant and he tells them whatever he tells them, and we find for whatever reason that that questioning was violated the Constitution and that the statements to the police should be suppressed. And then at trial, the police call a witness who says that the defendant told the witness exactly the same things that the police, that he told the police. Under your theory, the testimony at trial would need to be suppressed because it's another way of getting at exactly the same information that had been obtained in violation of the defendant's rights by the police?
Not necessarily. I think in Your Honor's scenario, that the point there is not just exclusively the police misconduct or the character of the police conduct. Here, we have just exclusively analysis into what the officers at booking did that did not include other ways, other avenues that the Commonwealth could have pursued independent of that police conduct to get that evidence in. Here, there is no other way to do it other than they got the motion to compel, which is effectively a way to circumvent the Fourth Amendment here in order to get that same evidence that they needed in order to make their case. And certainly they met that under Maxwell. But I think that were this court to remand and have the motion judge.
You keep on saying to circumvent the Fourth Amendment. Isn't the Fourth Amendment satisfied by the finding of probable cause to get the sample?
Not necessarily. Here we have, without the unlawfulness of the initial taking, then yes, but we can't overlook the fact that this thing exists already, pre-indictment, that this thing happened. And now the court has to address, the motion judge in some fashion has to address how that plays into the decision to allow the Commonwealth's motion to compel. Left unaddressed, then the Commonwealth could always then get this second bite of the apple without looking into the character of the police conduct at the initial unlawful taking. If I could just very briefly, I see you're on.
Yeah,
I see that my time is up.
Let me just ask, does anybody have any questions on the other issue?
No.
Okay, we're all set.
Thank you, Your Honor.
Thank
Rest on the
you.
brief. Thank you.
Okay, Attorney Jansen.
Good morning. May it please the court, Catherine Jansen on behalf of the Commonwealth. Just to start briefly, regardless of where the court comes down on whether or not any exceptions to the exclusionary rule apply, reversal is not required in this case based on the admission of the DNA evidence. It would have been harmless beyond a reasonable doubt. I'm not conceding that an exclusionary rule doesn't apply, but I just wanted to be clear that it was not the linchpin of the Commonwealth's case, and there was overwhelming other evidence that this defendant was the rapist.
Are you supporting inevitable discovery, or is this independent source?
No, Your Honor. In preparation for argument and review of O'Connor in the amicus brief, I don't think inevitable discovery is the appropriate exception in this case. I think independent source or attenuation would be appropriate, and this court, of course, can affirm on any ground supported by the record. As far as attenuation, just to briefly address that, I don't think there necessarily needs to be evidence regarding from the police officers who took the buccal swab or why they did what they did necessarily. I think part of the attenuation doctrine is you're looking at the purpose or flagrancy of the misconduct or error, and Commonwealth v. Fredette, which is cited in my brief, is very analogous, I would say, to this case. And in that case, it was important where they obtained the defendant's fingerprints via an illegal arrest, and those were suppressed. And later, 5 months later, a court order was issued to take those fingerprints again. It was important to the court's analysis, which is very similar to here, that the police didn't arrest the defendant just to get the fingerprints in order to have probable cause for the charges to be brought. And similar to here, police had probable cause to arrest this person as the suspect for the rapist, and in fact had an arrest warrant for him based on a confluence of other factors. And so it wasn't but for analysis. And I would also suggest the indictment, arraignment, and appointment of counsel are, quote, constitutionally significant intervening factors, as well as 3 years as a temporal part of that test. So I think attenuation would be appropriate here. But I also think independent source would be as well.
Could you please turn to addressing the SBI issue?
Sure. I would suggest that first, that this is not preserved. At the charge conference, defense counsel requested language similar to that's required for section 13A in chapter 265 for the YO element of substantial bodily harm. And that is, that was at transcript volume 196 through 200, volume 4 through 7. And so this is not a preserved issue on whether or not there should have been a greater explanation or definition on serious bodily injury in the context of aggravated rape. That being said, the jury instructions, the Model Superior Court jury instructions don't give a definition. And I also think that it's in the purview of the legislature that if they had wanted to put a definition similar to Section 13A or the other sections highlighted in the amicus brief that had a higher level of severity for serious, they would have done so the two times since they've amended Section 22 and in light of the common law development of seriousness. And it was in the purview of the legislature to determine that a more expansive definition of seriousness in the context of rape is appropriate as defined by
What's the
common
evidence
law.
in the statute that they intended a more expansive definition than the numerous definitions of SBI that are already in Chapter 265?
I'm sorry, can you repeat that question?
What's the evidence in the statute that they intended a more expansive definition than the numerous very similar definitions of SBI elsewhere in the Chapter 265?
I think it comes from the fact that many of these other, they could have, if they wanted to, add a definition, and they didn't. And I think the common law is clear that when a legislature has, when it's when a word is not defined in the statute and it's been defined by the common law, and then the statute's been since amended and they haven't changed it, or they would have, to agree with maybe how they want the level of severity to be, they would have done that if they wanted to, and they didn't. And JG, as an appeals court case, that I think is very helpful for this analysis about where we get that legislative intent for a more expansive view of serious opposed to how serious is defined in those other statutes within that chapter, if that answers your question.
What about the sufficiency of the evidence?
Yes, Your Honor. I think under where this was a general verdict slip, and so we don't know, and they were instructed on all three prongs of aggravating factors for rape, which were serious bodily injury, joint venture, and done during the commission of the felony. I do think it fairly gets there for sufficiency for serious bodily injury. I would say I could not find a case exactly on point. Usually there's more of a confluence of factors. Here, I would suggest her testimony was very limited, that she was pulled, he took her by the hair, I believe, and moved her head down to put it on his penis, and that 4 or 5 hours later she reported a headache would maybe be sufficient, but also conceitedly.
Wait, do the first two show injury or force?
I'm sorry?
The first two things you listed, you're saying they constitute injury?
I think it's all part and parcel. I think that probably the headache is the more than fleeting pain that's caused from that act of bringing her head down by pulling her hair. Or I don't even know that the testimony was quite pulling the hair.
Right.
But I would also note that I didn't really notice this when I was briefing it, but in further preparation of this case, the jury were instructed on joint venture as well. And while this was a joint venture for breaking and entering, I don't think the evidence was sufficient that there's a joint venture to commit the rape, and it was a general verdict slip. And so where we don't know what aggravating factor, it was clear from the Commonwealth's closing that it was during the commission of a felony, but they weren't so instructed and the verdict slips were general. We can't say for certain which aggravating factor they found. And so I think the aggravated portion probably would have to be vacated. However, this court could affirm on the lesser included of rape and remand for resentencing on that.
Okay.
I'm happy to answer any other questions. Otherwise, that Commonwealth will rest on its brief.